respect everybody's time, so I feel good about getting started. Thank you, everybody. Wow, we're up to 20. That's awesome, including us. For everybody for joining on a Friday, really appreciate it. My name is John Beebe. I'm the business coach with Craft3. This is our second in our workshop series of the Business Builder webinar workshop series, where we have key professionals in areas of business that we get to listen to and get amazing information from to help build our businesses. These generally are topics that come up universally on for a lot of businesses across industry based on the growth of your business, where you're at, some of the challenges and opportunities that present themselves. The cool thing about this webinar series is that it will live evergreen when it's of service for you, for your business, on our website and then on our YouTube channel as well. So we have Jennifer Peterson, who's an amazing marketing person on the call that's going to help curate all this down and get it all edited down for us. And so I'm going to hand it over to Aldo Medina, the Business Services Program Lead, for introduction.
Yeah, thank you, John. And again, thank you everybody for joining us this morning, whether live or in the recorded version. As John mentioned, my name's Aldo Medina Martinez. I use he, him, el pronouns, and I'm the Business Services Program Lead here at Craft3. Again, super excited to have you here. I'll talk a little bit more later, but I'll pass the word on to John so that he can introduce Janaya. Thank you.
Thanks, Aldo. Yeah, and our key specialist is Janaya Carter. She's a senior corporate counsel at Equinox Business Law Group. She's been an amazing resource already for all things business legal related, and she's going to cover a lot today, a lot of ground today. And I'd really encourage you to actively listen, take the notes however you feel. There's going to be time for questions and thoughts and potentially some scenarios we can run through. So I'm going to go ahead and hand it over to Janaya.
Good morning. Thanks for having me. I'm excited to be talking to you guys this morning about kind of how we go about advising our clients on choosing the correct entity structure as they're getting ready to set up either a new business or maybe change their business model. And then we'll also be touching on contract essentials and risk associated with contract clause that you might be looking at as a business owner. So key factors that we'll be talking about in selection are things that you should be thinking about. Who is going to primarily be holding ownership of the business? Who are your prospective business partners, and how does that impact the entity that you select? It can have ramifications based on where those parties are located or who they are. Liabilities that are assumed by the business, whether those are really housed with the business itself or whether or not the owners take some liability. And sometimes your business structure that you choose will dictate some of that. Tax considerations that you should be thinking about when you're choosing a business entity. How the day-to-day management of the business actually happens, depending on your business structure. Sometimes you may be both the owner and the manager and wearing all of the hats in the business as you set something up. And sometimes you will have, a key partner that is going to be more interested in the day-to-day management of the business. And so how you structure your entity may be dictated in part by that. The administrative costs that are sort of associated with different entity structures. And so that may dictate why you choose one ownership structure or entity structure over another. And then we'll also be talking about documents that sort of go with each of those entity structures and common contracts and their provisions that you may be running into as a business owner and things to be thinking about. In Washington, we do see a handful of commonly used structures. Some are more common than others. So we'll be touching on and talking about sole proprietorships, C corporations, S corporations, limited liability companies, and also partnerships, and kind of what the advantages and disadvantages and things to think about are for each of those. I also think that sometimes we get some confusion over entity structures and tax elections. So we'll also talk about that, because you can be For example, a limited liability company that chooses to be taxed as an S corporation, and you've made that election. And we'll touch on that in the business entity structures. Those are the most commonly used entity structures in Washington, and that can vary by state. For instance, if you're in California, you see a lot more partnerships than you would in the state of Washington. There are reasons behind that. So when we talk about corporation structure, there are really three main groups that exist in the corporation structure: shareholders, who are the owners. They elect a board of directors, and then that board of directors will appoint officers. So shareholders are the owners of the company, directors, board of directors kind of make most of the major decision making, and then officers who typically run the day-to-day corporate behaviors. A lot of times when we are starting at a new corporation or a company is earlier in its kind of corporate formation and growth, you may see parties, the same parties that kind of hold those. They're both a shareholder, they may be a director, they also may be a corporate officer. And so sometimes you'll see, it's very common to see kind of those conflated. So it's really important when you're acting as a business to kind of think about what hat you're wearing, and kind of how you conduct yourself within that business. And from a corporation standpoint, sort of maintaining those different roles and the separation is important for corporate identity. So we'll talk about C corporations first. I think that for all of us, they're probably the most visible. And the reason that I think they're the most visible is that the big mega corporations are sort of who we think about as being a C corporation. Interestingly enough, corporations really only make up about 5% of business entities in the United States. But when you think about kind of publicly traded companies, they tend to be kind of bigger corporation structures. When we think about kind of C corporations and ownership structures, any number of individuals and organizations can be shareholders in a corporation. So it does allow for a lot of flexibility. And it does allow for kind of, if your prospective growth is to become a very big company and eventually do things like look at whether or not you can obtain venture capital or you want to go public, you may choose a C corporation for that reason. And we do have corporate clients that start as one type of organization, and then as their business progresses, from a strategy standpoint, will actually decide to convert their entity, and that is possible. So I also want you guys to know that you're not locked in once you've elected to be a corporation into that particular entity structure, or if you choose an LLC structure, you just have to think about sort of tax planning and the tax ramifications. For both a C Corp and an S Corp, when we talk about liabilities that the business is assuming, one of the advantages is that the corporation is liable for business debt and judgments. So when we talk about liability, sometimes it can be sort of a foggy concept until you're actually there. So let's say, for instance, you design a C Corp, and your business function is to invent and design toys. And you put a toy out to market during Christmas time, and it is wildly successful. But unfortunately, what you didn't realize was that there was a flaw in the product. And that product, when it goes to market, causes injury or damage to the children that are playing with it. As a corporation, you may then see lawsuits around those injuries. So let's say that, unfortunately, that lawsuit is successful. And what happens is the court says, okay, there's been damage as a result of your product. You have caused damage and injury to these children. We're going to award that group of children $15 million. And maybe the corporation doesn't have the ability to pay that $15 million. And maybe the corporation doesn't have insurance in place that would cover that. Typically what's going to happen is that a judgment would be entered in that case, and that judgment is going to seek recovery from the corporation. And how it can do that is by attaching the corporation's assets. So things like cash in the bank, your accounts receivable. Maybe your company has equipment or vehicles. The benefit to kind of the corporation, the liability structure, is that The recovery on that judgment, assuming that you've maintained all of your corporate identity, would be limited to the things that the corporation owns as assets versus you as an owner being responsible for the $15 million. And so that is the benefit of having an entity structure in this way. If you are a shareholder of the company, your liability is limited to your capital investment. So let's say as you're starting a company, you invest, $100,000. That $100,000 would be reachable as a judgment attachment, but that's it. Like you wouldn't have to worry about like, are they going to be able to take my home or my car or, my other assets in my bank account? And so that's what we're sort of talking about when we talk about liability. For management for both a C Corp and an S Corp is that the shareholders of the companies, the owners, elect a board of directors. And then that board of directors will appoint officers to act on the day-to-day. So, this would be your president, your COO, your CEO that are going to run the organization on the day-to-day. The downside, the disadvantage to a C Corp structure is that it is exposed to what we call double taxation. And what this means is that the corporation is taxed on the corporation's income. So let's say this particular corporation made $3 million. That corporation is going to pay taxes on that income. And then when it decides to issue dividends to its shareholders, so let's say that the company decides, okay, we need to keep a certain amount for operating expenses to cover liabilities, but this year we're going to provide dividends in the amount of $1 million. The shareholders that receive those dividends as a result of their interest in the company will also be taxed on them. So that is one of the disadvantages of having a C Corp. The other things that we think about when we are talking about corporate structures is that there are filing fees that are associated with, they tend to be a little bit higher than some others as far as when you're filing with the state, and you do actually have to file annual reports and keep your entity status up to date. There are a couple of documents that run with being a C Corp. Articles of incorporation and bylaws are required by the state statute. And then we always recommend that the parties have a shareholder agreement. We'll talk a little bit later about kind of why those, documents are different and what are the advantages to them. And then there are significant ongoing maintenance activities. And what I mean by that is that the statute requires that you hold annual meetings. So you will have to hold both shareholders and directors meetings on an annual basis. And obviously you might be meeting more often as a board of directors to be dealing with kind of the things that are coming up in a business, but those meetings are required. It's really important to maintain your corporate structure so that there's no risk associated with losing your liability protection. So the other corporation that we'll talk about is C corporations, because I think that they tend to be more common, especially in this area. Ownership is a little bit different. You can have up to 100 individuals become shareholders. So you are capped at a particular amount. And then the other thing that's a little bit unique about the C Corp status is that an owner in a C Corp cannot be a non-resident foreigner. So let's say that you have a business idea that you are developing with a prospective partner in Brazil. And that party lives in Brazil year round. You guys want to form this company and take an idea to market. That party could not be an owner in an S Corp because the S Corp election and protection would be destroyed by having a non-resident foreigner. And that is the case whether or not we are in an S Corp as itself, or if you have an S Corp election. So it's also important when we're talking in the future slides about, let's say maybe you establish an LLC that is elected to be taxed as an S Corp, those same rules would apply. So being careful about kind of who you add as business partners can be important. Liabilities are the same as a C Corp in that the corporation takes on the liability structure and that shareholders' liability would be limited to their capital investment, and management looks the same. The big difference between a C Corp and an S Corp is that your taxation structure is different. The corporation itself is not taxed on the income. So we talk about that $3 million, the corporation doesn't have to pay taxes on it. What happens is when there's a distribution to the shareholders, they would pay a tax on it. So they aren't exposed to that same kind of double taxation standard. Administrative costs are similar to a C Corp in the documents that you would establish. When you kind of go through establishing an S Corp, there are some different changes within the documents themselves, but the documents would look the same. And then as far as ongoing maintenance activities, it would look very similar in the sense that you would be holding those annual shareholders meetings, annual directors meetings to maintain your corporate identity. Probably the most common business structure in the state of Washington that we see is an LLC structure. It is very common here, and that's because there's a lot of flexibility, and it is a simpler entity structure, and we'll talk about why it's simpler. The LLC structure differs from the corporate structure in that really you're going to have two major groups. Your members, who are the owners, and then you potentially could have managers. That's really an optional structure, and we have clients that elect it or not elect it for particular reasons, and we'll talk a little bit about that when we talk about kind of the structure. So a limited liability company, as far as ownership, one or more individuals or organizations can become members in the LLC, and so sometimes you'll even see within an LLC a different LLC becoming the member. So for instance, maybe you have kind of a law firm, and a law firm has established a PLLC as their primary business mode, but maybe they want to have a secondary company that does non-legal services. Potentially you could see a structure where they have established an LLC, and maybe that other entity is the member of the new LLC for consulting. As far as liability is assumed, it's very similar to the corporate structure in that the LLC is liable for all business debts and judgments, and then the members' limited liability is limited to their capital investment in the company, so similar to kind of shareholders. Management of the LLC is a little bit different and sort of flexible. So you can either be a member managed LLC, and when we talk about member managed, let's say that you have two business partners and they're both going to be engaged in running the company. Maybe one is the president, one is the chief operating officer, and they're going to run the company normally on a day-to-day basis. And maybe when they start the company and they're kind of earlier in their corporate status, entity status, they might decide that they're going to manage the company together. And so their agreement might be, okay, my business is operations, your business, part of the business is sales and marketing. So we're going to agree that the entity is going to be member managed. So we're both going to operate it, we're both going to run it. And we each have decision-making as to our area of the business. And then maybe there's a group of like 5 behaviors that we want us to act together. So, they're usually big decision-making. Maybe you, depending on the size of your business, you say, okay, any contracts over like $1 million, we have to have unanimous decision-making amongst the members to actually sign on that contract, or to change our corporate entity structure or something like that. Alternatively, you can have a manager-managed LLC. And we commonly see this where there are more than 2 members in the LLC, or there is a member of the LLC that wants to maintain control of the business, but might be interested in bringing in equity partners in the business. And so a manager-managed LLC essentially sets out in its documents that the day-to-day operations of the company are going to be managed by this particular manager. And they're going to be in charge of certain behaviors within the company. Maybe it's contracts up to $2 million. And then it sort of sets apart some behaviors like dissolution of the company or amendment of the LLC operating agreement that would have to be decided on by the members together rather than just the manager. So there are some benefits. I think when you're a small LLC and you're very closely working together as partners, it can be easier to have a member managed LLC, but as you get kind of more mature and you start to hire some executive level talent to come into the company, having a manager managed LLC can be simpler. The LLC structure is also very flexible as far as how you are taxed. So if you're a single member LLC, the default tax treatment is just a sole proprietorship. So whatever your tax rate would be, that's what your tax rate will be as far as the LLC. If you have two members, so the default status is a partnership, but you can elect to be treated as a C Corp. So typically there's just an additional form that happens. And so you could have the benefit of kind of the C Corp status. The only kind of qualifying that we talked about a little bit earlier is kind of maintaining, the C Corp status as far as who can be owners and making sure that you don't sort of destroy that by bringing in, let's say, a non-resident foreigner as a business partner. That would destroy your S election. There are also administrative costs associated with the LLC, but those administrative costs are typically high filing fees. It is a simpler corporate structure from my standpoint than a corporate structure, in that really what is required is a certificate of formation. The statute doesn't require much beyond that. So we always recommend that parties have an operating agreement so they understand how they're going to work together. But it's not required in the statute, and you don't actually have to hold meetings like you do from a corporation.
Okay, so we've got some really good questions. Thank you so much, Janaya. That's super informative. I actually learned a ton about the different structures, which I don't know if that's good or bad. Probably good.
It's always a learning opportunity.
So we had some really great questions, and then I had some thoughts and questions, and people are putting them into the chat right now. So I want to make sure that I give you space to not have to speak out loud for a minute, but be able to do it. Ashley was asking in the chat, and this is a really interesting question, really great question. If there's a way to sort of like gauge the cost associated with each, sort of like what this is about, what a C Corp will cost, this is about what an S Corp will cost out of pocket, LLC will cost this out of pocket. I know that's really rough, but it's kind of things. You have filings with the state, you have articles.
It'll depend by the state too.
It depends on, that's kind of, I put that in the chat. It kind of depends on the state, but
yeah, I think that's an interesting question. And I always think about it hard cost versus sort of soft cost. When we talk about cost, yes, there are administrative costs associated with filing with the state and then filing your annual report. And those are fairly similar between corporations and LLCs. So it can be several $100s to set up with the state to set it up, and then also to kind of file your annual reports and things like amendments and stuff like that. When we talk about cost, we're also from a law firm perspective thinking about like, what are your costs internally? So things that we think about is that you'll have more documents that you need to create in order to establish a corporation over, say, an LLC or a partnership or a sole proprietorship. So you will have to establish, obviously, your articles of incorporation, but you also have bylaws and then the shareholder agreement. So there will be a relative cost with creating each of those documents. And then internally for you, there is a cost associated with kind of maintaining your corporate identity. So you have to remember to actually set up the meetings in a timely manner. You have to actually do consents and things like that as you kind of run through particular decision points. And so there's actually an internal administrative cost too on your part. We do some of those things for our clients. So like we will do everything from like notices to make sure that the notices get out appropriately, but also running the meetings and doing minutes. But if you don't have someone kind of taking on that role for you, those are things that you'll have to actually think about. And so I think that's partially why a lot of folks will choose the LLC structure over a corporation structure, because there is not a requirement to hold those annual meetings. It's just a simpler structure. And when we establish it, you're just really looking at the certificate of formation, which is fairly easy, and then the operating agreement, and you don't have that sort of third agreement out there. So I would say from a corporation standpoint, it's probably, ongoing maintenance internally for administrative things. And then I would say probably a few $1,000s difference between a corporation and an LLC from our standpoint. And so it's kind of hard to give you an exact amount, but those are the things I sort of think about and coach our clients on.
Yeah, thank you. Yeah, I knew it'd be hard to like nail it down because it really depends stuff, but that's super helpful. Yeah. I actually had a question in this came up in the chat from Sonia and a couple other people as well. When you start out as an LLC and move to an S Corp, not necessarily for taxation purposes, but actually do the elevation of your corporation. Obviously there's costs associated with it. Are there certain parameters that are good to adhere to? Is that an annual review thing that you want to take a look at? I think that's another reason that I thought this was a good opportunity to have this workshop in December for corporations and all the different levels of companies to take a look at their structure at end of year.
Yeah. I think that it can be done annually. I generally find that for my clients, when they're making that decision, it's happening as a result of some sort of occurrence in the business. So they have sort of reached a plateau where they want to be, and they've decided to go out and try to get venture capital. And sometimes if you're an LLC and you're talking to venture capitalists, they may be less familiar or less comfortable with an LLC structure, and so they may want you to convert the entity. Sometimes clients will decide to convert from an LLC to a C Corp because they're looking at prospective sale in the future. Or they're trying to bring in sort of different business partners. I would say that probably one of the most important things when you're talking about converting is making sure that you're engaging your tax professional, because there are tax ramifications if you don't do it right. And so you want to kind of be careful at how you convert from units to shares and what that's going to look like. And the other thing is just sort of being knowledgeable and understanding about the fact that there's probably going to be some discomfort amongst the members as to kind of that structure change and whether or not they're losing things in a change from an LLC structure to kind of a corporate structure. So sort of thinking about that and being aware of it, and having some sort of professional that understands the dynamics of those can also help to sort of ease that transition, because the documents themselves are going to look different. And so when you talk about converting, you're converting the entity structure, but you're going to have to do a whole new set of documents as far as the articles and the bylaws and the shareholder agreement, because they're not the same documents.
Yeah, that's really good insight, because you're touching on something that it's people that run each of these companies, and people have emotions and vested interests that are outside of the articles of incorporation, right? And so I really appreciate the thoughtfulness of, hey, you when you think about changing entity structure, you need to take the people into account and really understand how that's going to play and make sure that everybody's on the same page when that happens. And I know that you touched on this earlier, and this came up in the chat, and we've had conversations around this. Later in the presentation, are we going to cover being taxed as an LLC, or sorry, being taxed as an S Corp, but as an LLC? Yes? Okay, cool.
Yes. Yeah.
That's one of those things. It's sort of in like the the small business cultural zeitgeist of everything right now, because there's the S corp loophole, right, that everybody talks about, that I'm not sure if we truly have a full handle on it.
Yeah.
So that'll be coming up, and great after the break. So we had a couple more. Let's see. We are at the midpoint, Jennifer just said. So I'm going to cover one more. I'm going to ask one more question, if that's okay.
Sure.
And then we save some of it for the end. We have a question from Taz. I was under the impression you need an operating agreement to open a business banking account for a 2-member partnership operating agreement. Is this correct or not correct?
Okay, so keep in mind that there's a difference between what is legally required and what your lender or your bank may require. And when we talk about, what we strongly recommend, there's reasons behind it. One is it may be difficult when you're dealing with other entities if you don't have an operating agreement. Also, the statute itself doesn't require that you have it. So that's the difference. Like if you're establishing a corporation, the statute itself requires that you have certain documents. You have to have the articles. You have to have the bylaws. The LLC, what's required is just the certificate of formation, which is very kind of narrow and doesn't contain a lot of information. The reason we suggest as a best practice having something like an operating agreement in place is it sets the stage for what expectations are between the parties, but it also sets the stage for what expectations are of you for outside entities. So I come from a real estate background, and I worked in title and escrow for a while. So when we were closing transactions, we always looked at operating agreements if an LLC was involved, because we wanted to know who was authorized to act and to sign those documents. And so you will see variations as to what's required. I have seen entities operate as an LLC for years and years that have never had an operating agreement. Yes. Yes. And I think a lot of times when we get into business, we always sort of assume that things are going to go smoothly and you're going to have the best outcome. And there's this sense of optimism, and I love it. But later on down the road, when we run into kind of some sticky scenarios, having those agreements in place are so important, because you've already planned for kind of how the parties are going to act in that scenario. So it is not uncommon for lenders or banks or title companies to require that you have an operating agreement in place for their own protection, and to understand how you guys are going to work together.
Mm-hmm. And I know we're getting to the next section, so I want you to have a breath before we start the next section. I will summarize that by thank you for all the amazing answers. Yeah. Thank you guys for all the questions. We hope to have some time at the end for more Q&A. And it's more expensive and takes more work to undo things that didn't happen when we were smaller and more flexible. So I really encourage you to take a look at where your business is at right now and make proactive steps for the future versus having to do forensic reactive steps back into when those things come up, when you're in front of a lender, when you're in front of a banker, and you have to retroactively go and do articles of incorporation. It's much more expensive, and it's much more difficult. So thank you, Janaya. And if we could start the second half, that'd be awesome.
Yes. So just quickly touching on documents for governance and ownership. When we establish a corporation, we talked a little bit about the articles of incorporation. They are legally required under the statute, and it's really going to define the company and its capital structure. So it's going to talk about things like, what is the name of the business? Where is your principal place of business? How many shares are you issuing? What do those shares look like? Do they have different classes? The bylaws is also a legal document that is going to be required. So it is the governing document that defines the roles of the parties involved, the shareholder, the board of directors, the officers, how often you're going to have meetings, like what's required as far as decision making. Do you have to have a quorum present? Is it just, is it a majority decision around let's say removal. I had a client recently that decided to remove a member of their board of directors. And so the bylaws really set out what that process looks like and how it's going to be done. We always recommend that you have a shareholder agreement. That is a contract. It is not a legal requirement. It's a contract amongst the shareholders, and it puts restrictions on transferability of the shares. One of the things that we see come up really common is that at some point, unfortunately, one of your parties is going to decide to get a divorce. And so what happens during that dissolution? Is it possible that the spouse then is granted an interest in the shares that particular party holds? How are they going to act? And so there might be a provision in your agreement that says, hey, shareholder, if you do get a divorce and your spouse gets the shares, that party is not entitled to a vote in running the company and decision making. It converts to what we call just an economic interest. So they might be entitled to dividends or distributions, but they're not going to get to decide how the company is run. We talked a little bit about annual meetings. So you have to do that for shareholders and directors. It is a legal requirement. And then you do have to make an annual filing with the state each year. And typically you're telling the state a few things like income, number of employees, things like that when you're actually filing that document. Simpler from an LLC standpoint, all that's legally required as far as documents is the certificate of formation. It also is going to define the company, its legal structure, who holds the ownership interest, whether it's member managed, whether it's manager managed. And that's a document that if we change that, it is changeable. We just do an amendment with the state, but it is something that you would have to notify the state on. We always suggest that you have an operating agreement, which is a contract. And typically what we tell our clients is that the operating agreement is sort of what you would expect to see in a corporation's bylaws and shareholders sort of combined into one document. And so those documents can look a little bit different. And then it's also going to establish how kind of governance is made, whether you have a manager and whether that manager is going to get appointed in the operating agreement, and then sort of decision-making thresholds for like, what are the decisions that you have to have unanimous vote of members? What are the decisions that you can just have your manager decide? And then it's also going to place restrictions on the members. And so one of the things that we did not talk about very much about is that in both the operating agreement and the shareholder agreement, we typically have restrictive covenants. And so that's things like a non-compete. And some of you might be thinking, wait a minute, non-competes are not allowed in Washington. So that would be a good thought. And non-competes are allowed in Washington. They're allowed at certain kind of levels, salary thresholds and things like that. But there's a carve out under the Washington statute that allows you to have non-compete with an owner of an entity. So if you think about it, when you're introducing someone into your company and you're giving them ownership interest, you're sort of giving them the keys to everything, and they can see how you market, how you make business decisions. They have access to your intellectual property. And so you can, as part of an ownership, have a non-compete in place that would prevent that party from then leaving your company and taking your information. We also do things like confidentiality and who owns the intellectual property of your company, which can be very important within those documents. And then with an LLC, you also do have to file an annual report with the state, but there are no annual meeting requirements unless for some reason, as an LLC, you elected to put that into your documents, which I've seen people do. The other thing that we'll talk a little bit right now about is, so you've established your LLC. Typically what happens is that when we're forming an LLC, we talk to our prospective business owners about what they want it to look like. What do you want the name to be? Who's going to run this? How do you want that decision making to look? We also talk about tax elections, like how do you want to be taxed? Do you want pass-through taxation? Do you want to elect to be treated as an S corp? And so when we talk about that, when we're doing the formation, there is a separate document that you file with the IRS, which is S election, and it's just a separate document that has to be filed within a certain amount of time. The timeline, I want to say it's 60 days from entity formation. We do that provide that service as part of our formation for our clients. And we just kind of do the S election as part of the formation documents and make sure it gets over to the IRS. So there is a difference between being an S Corp separately as a corporate entity status and being an LLC that elects to be taxed as an S Corp. And so really what the election is only touching on for the S Corp is that taxation status. Okay, I'm gonna hand it back over to Aldo.
Yeah, I noticed, John, you had a question. I don't know if you want to ask, or you had your hand up, but
I had my hand up, but it's just a really quick point, and Janaya, you can either nod or nod this way or this way. There are non-solicitation clauses as well that are separate, and this is something important to consider if you're working in a capacity of sales at the company you're at. No, compete is one thing. You're not allowed to start your own company and compete, with net space. But non-solicitation clauses are very common, both in Oregon and Washington, and you need to keep an eye out for those depending on how you're set up, or you need to consider writing those in depending on how your company is set up. You can take that offline. We can talk about that later.
Yeah. We also will typically include non-interference provisions in those documents so that there isn't like an argument that like, oh, these were our clients beforehand. If a party is actually interfering with your contractual relationship or trying to divert business from your company to their company, those provisions can be very useful. And we actually see them used on just a daily basis around kind of what a party is allowed to do and how they're allowed to engage with your clients.
awesome. Thank you, Janaya. So right now I'll just transition real quick to say a couple of things. I want to be conscious of time and we want to end by noon. But I want to invite everyone.
Although you muted yourself, buddy. I know.
Of course. All right. Well, a lot has been shared. Thank you. I don't know where I think I pressed the enter button and that muted me, but a lot has been shared and I want to just, give kudos to Janaya. I want to invite folks, just to be on time and be conscious of the time. I put in something in the chat that really summarizes this, but for the folks that are just listening in or driving, don't do this, but for the folks that are actively at their computer, I put a couple questions just to take time to really reflect, pause. And this recording will actually be available after the fact. And so I would encourage everyone here to go back and, pick up some of these nuggets because it is a lot of information. And so just thinking through, if this person is all one person, then great. But as the business is going to grow, as it's growing, who runs that business day to day, who makes those decisions, who takes on the risk, liabilities, the tax implications, and then what are those administrative costs? So I want to invite folks just to think about that, reflect with that, sit with it. And just for the folks that are joining live, but also, in the recording in the future. And then I want to invite you to think about some of the other considerations. And so if Janaya, you can move to the next one. For the folks that are just listening, I want to read out these because I think they're really important. Whether you're operating your business already or, you've been in it a few years, it'd be a good opportunity to just rethink about some of these things, right? So if unfortunately something happens, there's a disability or a death occurs, what is planned for the business, right? It's an asset. And so who has the authority to step in? What does succession planning look like? Who is that key person and is there insurance for that key person? What does that asset protection look like? And then how does that all affect the ability to secure funding and or investments? And so, want to walk through this piece, I want to say that out loud, but also just invite folks to take some time to think about these things because oftentimes we're going so fast. And some of these things are, maybe not top of mind, but they're definitely critical and important for the continuation of the business. And so I want to offer that, take it as you may, like I said, watch the recording again, because I think there's just a lot of depth in here. And so I'll hand it back to Janaya, just to keep going on it just for the sake of time. But yeah, thank you.
Of course. thank you for doing that. Okay, so the other thing that we'll touch on just really quickly is sole proprietorships. Obviously, they're easy to start. There's not a lot of setup to them. You're sort of establishing yourself as the business. The downside to it, and I saw a question come across, is when do you consider converting from a sole proprietorship to an LLC? And I think that's a really important consideration. I think that one of the disadvantages of a sole proprietorship is that the owner is personally liable for the company's debt and liabilities, which puts their personal assets, such as their home, at risk. And then when the owner dies, the business becomes part of their estate. And we'll talk a little bit about why that matters. But I typically think about looking at what the risk is involved in the business. So as you grow as a business, your risk gets naturally greater. You're engaging in more contracts. There is more complexity to the business. There are more opportunities for things to go wrong. And there are strategies that you can engage to offset that risk. And we'll talk about that in the contract section. But insurance is a great one, making sure you have an insurance broker that is very engaged and is proactive. And there's a difference. And so we typically engage with some insurance brokers that are looking proactively at our clients' businesses and anticipating what they will need in the future, and talking about what are the products that maybe you don't want to pay for right now, but you should be looking ahead at. And so when you are looking at the possible risk and liability of your business and it becoming large, and you have established your own personal assets that you want to protect, that is a very good time to look at an entity structure. There is the availability of partnerships in Washington. We do not see them as often. It is a huge entity structure in California. The reason we don't see them in Washington, I think, is that if you're running a general partnership, all of the partners have personal liability. People do utilize it because it's easier to set up. And it's really designed, a general partnership is really designed for when one or more partners is actually running the business. So maybe you don't have a sole proprietorship because there's two of you. But again, when we're talking about personal liability, when the business gets more mature and you're starting to take on more risk and liability associated with it, you may want to think about that. Limited partnerships exist. And so usually that usually is used when there's one party to the business. So let's say you have those two parties, but one is like, I don't really want to run this business day to day, but I'm willing to give you some money to get started and invest in the business. That party may decide to be a limited partner because they don't want any personal liability to attach to them, but they're willing to invest their money and expose it to risk associated with the business. It's a little bit more complex to form because it does have required filings and some administrative expenses. But that is available in Washington. We don't see it a lot because I think folks tend to favor LLCs. And then it has pass-through taxation. So maybe we should just for a second get a little bit more minute on what I mean when I talk about taxation, because it will matter. So when we talk about pass-through taxation, we're talking about, as a business owner, how am I going to be taxed? What is my rate? So let's say that my rate is 33%. And that's going to be figured in when I'm trying to decide on my entity structure. I think the current business taxation rate is 21% right now. And that fluctuates based on what the government does, right? So like, are they giving tax breaks to businesses? How are they doing that? How are they structuring it? So historically, over the last few years, that rate has ranged anywhere from 15 to 35%, pretty big, wide range. So 21% might sound pretty good if you as a business owner are taxed it at 33%. And so in that case, you might be deciding, okay, I am going to establish an LLC and I'm going to have an S election so that I can bring down that rate from what I personally might be liable for. So those are some of the things that business owners are thinking about when they're trying to decide on entity structure. There are some additional entity structures that we'll just talk about really quickly in Washington because they don't come up as often. A PLLC, so it's a professional limited liability company. So let's say as a business owner, you want to form an LLC, but you are an accountant. You cannot form an LLC, you have to form a PLLC. And the reason that exists is that as a group of folks that are licensed from the state, we have greater liabilities that attach to us as a result of typically ethical standards. We might have, medical malpractice standards, those types of things. And so the PLLC sort of finds a way to wed the idea of limited liability structures and kind of having enhanced duty to clients or customers as a result of being a licensed professional in the state. So that's why you'll see, like, our business name is PLLC. That's because we're a professional limited liability company. And then nonprofit organizations, which are typically organizations that are formed for promoting social causes and advocating for a group that needs help and is engaged in community benefits in some way. A nonprofit organization, I did see reference to this in the chat, may have tax exempt status under Section 501c3. There is a process for that. And so when we talk about sort of tax exempt or tax elections and then business entity structures, those are sort of kind of different, but you actually go through a process to get a 501c3. And you can be a nonprofit corporation in the state without having a 501c3, or you can have a 501c3. So, okay, we're going to be moving on to contract considerations and touching on things that you would typically see really quickly because we are running short on time. So contract considerations, when we look at a contract as attorneys, when we look at a contract as a business owner, it's important to identify elements of risk. See if you can negotiate the risk in the contract. And if you can't negotiate the risk, how do you identify ways to decrease the risk? And so things that I would say to be looking for, we identify as being high risk areas, is the value of the contract. So is the value of the contract large? If we're talking about a $2 million contract, damages that flow from breaching a $2 million contract are naturally going to be larger than, say, a $50,000 contract. How you act in relation to those contracts should be different. Is the party asking you for a personal guarantee? And I'm seeing a lot of personal guarantee language, and also what I'm seeing in leases a lot right now is a section creeping in where they take an interest in your fixtures and your equipment. As an attorney, when I'm looking at that, I always strike that for a variety of reasons. It's really not necessary, but also it might trigger other issues if you have lending relationships on, say, your fixtures or equipment. So are they asking for that? And that may be because they identify you as being higher risk, but that would mean that you are personally liable if the company defaults and that they can come after your assets. Indemnifications, looking at the indemnification clause and looking at whether or not it's mutual. Are they agreeing to indemnify and you are agreeing to indemnify? Can they withhold your payments if there is some sort of a breach under the contract? Are you agreeing to defend them? And if so, can you control the defense? So it may be a little old-fashioned, but I typically say that you should really be coming into a business relationship the way that you intend to conduct yourself. And if what I'm getting is a contract from the other side that is very one-sided and they're unreasonable about modifying the contract in any way, that makes me anxious for my client. And so, when we look at contracts, especially when we're looking at the same scenario and one is much more unfavorable, I am concerned that the party is going to conduct themselves in an unfavorable way throughout the contract and when it goes bad. So something to be thinking about. Contracts can have warranties. Oops, sorry, guys. So thinking about how long the warranty is. So in that toy example, maybe you're agreeing that you're going to give them a warranty on the particular product that you're producing and kind of how long that warranty lasts for. Can you limit it to 1 year or 3 years so that what your outer liability looks like? Like, if this goes bad, is it going to be something that I have to worry about forever? And then designating indemnification as an exclusive remedy. So let's say you say, I'm going to warranty this toy and like the fact that it's going to be fit to be used for 3 years. But if for some reason there's an issue with it, then what you can do is you can come back to me and you can require that I indemnify you from any damage or injury that could occur as a result of that toy not meeting the warranty that I gave you. And then also including a limitation, we commonly call them a cap on the overall amount of a party's liability. And so how we see this happen is, you know, maybe it's, I'll give you this warranty, but up to a limit of $10,000, or some sort of liability cap on the amount that you're required to pay the other party in total. The other areas that we'll just touch on very quickly: governing law. Where does the contract say that if things go badly, you are going to litigate this issue or go to arbitration or mediation, and then our prevailing party is covered? So typically, and I think this is probably one area where I never see clients push back, but if things go badly and you have to go to, you know, Florida to litigate the issue, there's going to be a cost associated with that. And I'm starting to see some creative provisions around this, which have what we call reverse jurisdiction. And it says, hey, you know, client, if you sue me, you have to come to my jurisdiction. And if I sue you, I have to go to your jurisdiction. And the reason for that is it provides an incentive to not sue, right? To come to some sort of mutual agreement. So thinking about those things and not just kind of signing the contract. And then things like liquidated damages. Are you going to have to pay the party if there's a breach of contract, you know, $50,000, $100,000? Striking special, consequential, punitive, or indirect damages. There's very few contracts where I would say that that's probably appropriate. So, you know, we talk about things like punitive damages. The court can award punitive damages to punish you for the behavior that you engaged in. And sometimes those damages can be huge. They're actually making a point. Assigning a liability cap. So what we're seeing very often is, you know, maybe the cap is, if something goes wrong, I agree to give you no more than the total amount of fees that I was paid under the contract in the last year. So things like that. And then making sure that you're excluding losses that are occurring as a result of the other party's actions. Last, making sure that you have good insurance in place, you have a good relationship with your insurance broker, and seeing if there are ways to kind of draw down your risk and liability by having insurance in place that would help to cover some of those occurrences.
Look at that. It's really only 2 pass. That was amazing. Awesome. Janaya, would you do me a favor and forward to the next slide? Just so for people and we had a great retention rate of people. Clearly, we're covering a lot of content. You are covering a lot of content. That's really, really important. I felt like I was nodding my head the entire time because I think these are incredibly important topics. These are really good takeaways for everybody on the call. Opportunities for next steps. You can kind of read this, scan the QR code if you want to on your phone. I know that. Thank you so much, Jennifer, for putting that in the chat. There's the link to the attendee packet and suggested topics. We do want to have a survey for topics in the future. Janaya and this topic itself was something that it's really been pressing, and I feel really strongly that this is a wonderful time of year for all of you to take a look at your business entity, your business structure. Just absorb this now, take some time with it, and then revisit it later and see what really stands out to you as opportunities or maybe challenges for the way that your business is structured right now. Questions that you might bring up with you know, your trusted members of your team, and just take a look at it when you get a chance. We are going to leave some time for Q&A. We covered a lot of ground. And I think, Aldo, help me out on the chat. I think we covered most of the questions in the chat. But for those of you, there's a lot of people still on. And for those of you that are still on, if you, Janaya, can you spare a couple more minutes just for a couple questions? Cool.
Absolutely.
Yeah, and then this is all of our contact information if you want to screenshot it if you can safely, like Aldo said. Or just contact any of us as, you know, one-on-one as opportunities allow and thoughts and questions and concerns come up. While people are kind of formulating their thoughts and questions, contracts look at all the stuff that was in that last section. those are all of those things are in fairly simple, straightforward contracts that we unfortunately as human beings brush over. And a lot of those sections are really important to address. And this particular presentation, with the way that Janaya laid this out, I would encourage you, next time you have a contract in front of you and you look at it, bring up those slides and see if you can match what's going on in those slides, those topics, those challenges, those potential red flags to look out for into the contract that you're dealing with. And this is just a really good habit and practice to get into as we review our own contracts. As small business owners, like Janaya said, we have our head down and we are grinding and we are hustling and we're in our business and working in our business. These are opportunities to take a step back and work on our business, because that contract is binding once you sign it and once you engage in it. Although I don't know if you've had some takeaway. I saw you nodding a couple times with, especially with collateral assignment for assets. That's something that we run into quite a bit. So
yeah, no, nothing. I mean, ditto to what John said. Please reach out, use this as a resource. Again, we curated this. I think there was one question from Chloe that just came in, and I can read it out loud. So if you've already set up your LLC, is there no opportunity to do the S Corp election later?
You can do an S Corp election later. I want to say that there is a timeline under the form and a deadline before the start of the year that you intend to apply it to. And I can't remember it off the top of my head. I'm sorry, guys, but there is an opportunity to still make an S election later. There are two things to consider as far as timing and making sure that your S election is done in a timely way based on kind of when you want to be taxed that way. And then also thinking about the corporate documents that you have. So in other words, your LLC document, if you do have an operating agreement, may need to be amended just to make sure that it's consistent and doesn't conflict with your S election. And also think about who your business partners are. Do any of them sort of fall in an area where an S election would not be possible? Because we've seen that happen. And we've also seen circumstances where parties are in an LLC, have an S election, and then they admit members that destroy their S election without realizing it. And so there can be tax ramifications later on down the road when the IRS realizes that you don't qualify for the S election.
that's super helpful. Chloe said
Thank you.
And then Ashley ended that the whole thing about contract negotiations, how to approach those, bring those up. What I can say, learning from Janaya over the last hour, you have to advocate for yourself. You have to have an independent resource, legal resource, or someone on your team that is very well versed in this, in your corner. And obviously don't rely on the other parties' legal resources to advocate for you. I know that sometimes that can seem like a no-brainer, but just that's really important to take time to pause and just really think through that and make sure that you have your team around you before you enter into those contract negotiations. So I think that that's everything we have in the chat right now. We still have quite a few people online. If other people have thoughts, oh yeah, of course, Ashley. Yeah, absolutely. And really encourage everybody to take the time. It's a Friday. Thank you guys so much for doing this on a Friday. This was a great way for me to end my week. It gives me a lot of opportunity and food for thought as I get the opportunity to work with small business owners like yourself and continue to have us all try to grow and develop and keep these things on our radar. And like I was saying, as these habits and this awareness grows, it just helps us, regardless of where we are in our business journey, to have this language, to have these tools in our back pocket, to have these things to rely on. Just taking away those unknowns, any of those unknowns when you are wearing a ton of hats, to say, oh, I've got this in my back pocket. I do have these legal resources in my back pocket. I've got this content about contracts in my back pocket. These are all invaluable things that just help us sleep a little better at night, let our business operate a little more fluidly, and take time to work on our business and not just in our business. If Aldo or Janaya, if you have any last thoughts and takeaways, I just appreciate everybody's time.
Yeah, I was just going to say that, as a business owner, you've gotten here by being savvy and finding resources to help you along the way. And we kind of counsel our clients on you don't have to be perfect, right? Like where you're at in the business is where we really try to meet our clients where they're at. And so it may be that you were going 1,000,000 miles an hour to establish the business and utilizing that pace to obtain the opportunity, which is super important. It just may be that you have to go back then and really think about, okay, did I do what I intended to do? And if not, how do I make sure that I set myself on the best pathway going forward? And I sometimes think, especially as far as contracts, that sometimes when we're going so fast, we might feel a little bit panicked. And so we execute contracts that are not in our best interest. I just had a business client in this scenario that really needed some lease space. And I said, this is one of the worst leases that I've seen. It's not the worst lease, but and it's fine to sign it. Just go into it with the awareness that it is not in your favor. And so if things go wrong, like how will that impact the business and what sort of exposure there is? And they decided not to take the space, and they found a much better space and a much better relationship. And so kind of making sure that you're taking the time to pause and think about what are the possible ramifications if you do make that kind of panic decision because of a time constraint, I think is important.
Yeah, that's awesome. Thank you so much, Janaya. And I'll just round it out by saying thank you again to everybody that joined us today. Thank you to Janaya, to John, Jennifer, the whole marketing team for making this available. These are complimentary webinars designed for busy owners like yourselves. So please share this information, share the content with others. And we're excited to, be planning for 2024 to bring you some more content. So, please fill out those surveys, make sure to share some of these resources. And with that, I will let you all go. So happy Friday. Thank you so much. And you'll be getting some info from us here soon.
Thank you, everybody.
Bye.